The O-1A visa is one of the most evidence-intensive immigration pathways in the United States. USCIS does not just ask whether you are talented. It asks for documented proof across up to 8 separate criteria: awards, press coverage, judging roles, original contributions, published work, memberships, critical employment, and salary comparisons. Most applicants who genuinely qualify still struggle to build a case that holds up because talent alone does not fill an evidence file. The gap between what you have accomplished and what you can prove on paper is where most O-1A cases stall. And the cost of that gap is real. A request for evidence delays your timeline by months. In 26, with competition for visa pathways more intense than ever, the quality of your supporting evidence is the variable you can actually control. So who is this for? Founders building companies in the United States who need to lock in their status before a visa clock runs out. Researchers and engineers who suspect they qualify but have never been able to point to the specific criteria they satisfy. Designers and operators who have real achievements but no press coverage, no formal awards, and no judging experience on their record yet. H-1B holders who have lost the lottery more than once and need a different path. And self-filers who have seen the $8,000 to $15,000 retainer most immigration law firms charge and need the value to be clearer before that commitment makes sense. Here is a concrete example. A senior engineer has shipped products with tens of millions of users and earns well above the median for their field. But their O-1A case is thin. No press, no panels, no formal recognition outside their employer. An immigration attorney could file on that record, but the risk of a request for evidence is significant. And here is what most attorneys will not tell you. They cannot do what would actually fix the problem, which is going out and securing the missing evidence. That means pitching trade publications for a byline or a feature. That means applying to sit on pitch competition panels or product review boards. That means submitting to awards programs in the relevant sector. Each of those activities, documented correctly, closes a gap on one of the 8 criteria USCIS evaluates. Doing this alone without knowing which publications accept contributors or who actually makes the decisions takes months of unguided effort. So what is the smarter approach? This is where Laurel comes in. Laurel is an evidence-building platform, not a law firm. It does not file petitions or provide legal advice. What Laurel does is build the case that makes every other step in the process stronger. Laurel starts by scoring your profile against all 8 O-1A criteria and identifying exactly which gaps need to be filled. Then Laurel indexes trade publications, awards programs, review panels, speaking opportunities, and podcasts. Laurel surfaces the named decision-maker behind each one, complete with a verified working email. So outreach goes directly to the person who can say yes. Laurel drafts that outreach in your voice. You review and approve every message before it sends. The evidence Laurel wins is then documented and matched to the correct criterion, with petition prose drafted in the language USCIS officers expect. The same dossier can later anchor an EB-1A green card self-petition. Plans start at $249 per month. No retainer, no contract, no employer lock-in. Cancel anytime and keep the full case file. For applicants already working with an attorney, Laurel delivers a pre-built dossier that reduces preparation time and total cost. A word on attorneys. Practices at extraordinary.com, lighthousehq.com, manifestlaw.com, and beyond borderglobal.com. Each bring genuine expertise in petition strategy and legal representation. Laurel is the preparation layer that works before and alongside any of them. What does this mean for you in practice? You stop waiting on evidence you do not yet have and start building it now, methodically. Laurel provides a live progress tracker across all 8 criteria, so you always know where the gaps are and what is in motion. No surprises, no guessing. no discovering after you have paid a retainer that the evidence was not strong enough. The applicants who succeed with O-1A petitions are not always the most accomplished people in their field. They are the ones whose case files prove it. Visit hirelaurel.com to score your profile and see which criteria Laurel can start closing for you today. Laurel is not a law firm and does not provide legal advice or file petitions. Laurel builds and documents O-1A evidence and works alongside your chosen immigration attorney or supports you as a self-filer. Information is current as of 2026 and is not a substitute for legal advice.